It is beyond dispute that a principal ingredient of personal liberty is freedom from bodily restraint. So when he stops you, you can't proceed without, you've just waived all your rights. You just waived all your rights as soon as he stops you. Or he's waiting for you. The term liberty as used in state and federal constitution consists partially of the right to be free from arbitrary restraint is a fundamental constitutional right. My spell checker didn't work.
Spell right in here. Spell it different, but not right.
It's supposed to be restraint.
Would you mind going back to the previous one? Oh, how would you waive your right?
The officer waives them for you when you start talking to him. Remember we talked about that earlier. We're going to have to just stay with me because buy the tape afterwards because I'm only up on page about 40 and we've got over 100 pages to go yet and it's almost noontime. You know what I mean? Yeah. But wait till you see tomorrow. I got another 100. It's not in the book. Thus, the first issue to be determined by the trial court was whether the police officer's initial stop was reasonable within the meaning of the Fourth Amendment. If it was not, the Fourth Amendment violation might affect any purported consent. How did you do that? How did you set that issue up? Officer, are you conducting a criminal investigation? Yes, I am. Thank you. Now you set up the argument for this. I'm teaching you how to set these arguments up for each one of these court cases. Each one of these court cases creates a situation for you. You read the court case and take the verbiage out of it and you move the officer into that segment.
What you say he's not making criminal investigation.
Then I'm free to leave then, I guess. Then I'm free to leave. Three states have overturned roadblocks. You know, these roadblocks here? 3 states have overturned them. Police use of temporary roadblock to stop cars and investigate large number of drivers in hope of discovering evidence of alcohol-impaired driving by some of them violates state constitutional provision that requires police to have objective, individualized, articulable suspicion of criminal wrongdoing by driver before driver may be subject to investigative stop. That's 1994, Minnesota. They overturned, you know, these roadblocks they stop for drunk driving Christmas time? They overturned them in Minnesota. Maybe somebody will be intelligent enough get stopped in a roadblock here, you know what I mean? And learn the argument.
So if it goes to court, criminal wrongdoing. Making a U-turn is not a criminal wrongdoing. It says criminal wrongdoing.
Yeah, but making a U-turn is not a roadblock.
They have
Here,
to provide
listen.
an exit route for you in front of the roadblock for it to even be halfway constitutional anyway.
Absent articulable, persuasive reason for dispensing with individualized requirement, sobriety checkpoint roadblock violates state constitution provision prohibiting unreasonable searches and seizures. That's the way it comes in under. That's the second court case in Minnesota. There are 2 of them. Police officer may not rely on good faith, inarticulable hunches, or generalized suspicion to meet standards of reasonable suspicion to justify investigatory stop. The mere fact you had no plates is not reason to stop you. That's good faith. It's just a hunch he's got. He had no report of a stolen 1972 white BMW with no plates, also with pockmarked with rust. And he's got to have all to meet standard of reasonable suspicion. So he's outside his reasonable suspicion. If you know these court cases, you have your arguments. You know what I mean? That's a 1993 court case. While Fourth Amendment grants perhaps the highest level of protection to dwellings, it applies to people's effects as well, and thus applies even to vehicles and fixed structures. Realistic and proper expectation of privacy created by circumstances is crucial to determining whether a warrant is required under Fourth Amendment. So you have a reasonable expectation of privacy in your automobile. That's what the court said. At Federal District Court, New York, 1993. So if you know how to do the arguments.
Richard, as I understand it, these court cases that are not in this district or in California are not are persuasive but not mandatory authority?
Right, and you can dig up similar ones in this state. They got the same verbiage. No consensual encounter for purposes of Fourth Amendment occurred between police officer and defendant. The officer pulled over defendant's vehicle and began asking questions, requesting his documentation, indicating to a reasonable person that he was not at liberty to ignore officer and go about his business. That's a 1994 court case out of Utah. So, you have a reasonable expectation of privacy, you know what I mean? And you have done something wrong for the officer to stop you. Here's a good one, shows you the difference between state constitution and federal constitution. The state argues this case under the state constitution, conceding that the roadblock violated the Fourth Amendment. Therefore, the only possible reason the state's concession could render this case moot is that we have first looked to the federal constitution. By holding that this case is moot, we have implicitly rejected the primacy approach to interpreting our state constitution. Under the primacy approach, we would consider the state constitution. If the state constitution resolves the issue, we would not even consider the federal constitution. So always bring your state constitution in first. But the state argued under both. They said state and then quoted the Fourth Amendment. So they overturned the roadblocks there. In Utah, that's the second case, State versus Sims, 1994. Statutory interpretation. This is a good one for you guys. It's very important because you're going to do a lot of work on the words. Okay? Statutory interpretation. When meaning of plain statutory language is not clear, court refers to legislative intent to ascertain meaning of statute. 1995. So what do you do in a court case like that? You file judicial notice that the term vehicle is vague and ambiguous. Now the court has to go into statutory interpretation. Or you would, the word vehicle is vague and ambiguous, and this is what the courts has ruled it is. You know what I mean? Vague and ambiguous term, and show the court what it specifically means. Lay the guidelines out for the court to operate within, and the prosecutor's got to stay within those guidelines also. See? And the legislative intent of the vehicle code is that it only applied to commercial purposes. The objective of statutory construction and interpretation is to ascertain and effectuate legislative intent. That's what they're going to try to do. That's what you're going to try to make the court do. There's another one, Court of Appeals duty, you know what I mean? Here's a good one. If word or phrase has been assigned particular meaning in one part of law, then it is to be given the same meaning in another parts of the law. So if it says commercial vehicle over here, then the same law talks about vehicle over here, they're talking about the same thing. It's all commercial in nature. We got all cases, several new cases on this also. Whoops. I just kicked my...
So in this state, all that means the same word we say good state.
It depends on what it is. Which you have to look and check and see which is defined. This is Lundgren, Attorney General. Okay, now here's a good one that everybody should know, even before coming here. When construing Constitution, words are to be given their natural and ordinary meaning. Object of construction is to give effect to the intent of the people adopting it. When they adopted the U.S. Constitution and the California Constitution of 1849, the word person did not include corporations. It only included the word person after the Dictionary Act of 1871. Write it down. So that is a different person in the 14th Amendment than the person in the Constitution. So which person are you talking about, Your Honor? I don't quite understand. You're in federal district court. He says you're a person. I can see you're a person. Well, Your Honor, it's vague and ambiguous. Which person are you talking about? Are you talking about the person defined in the original Constitution or the person defined in the 14th Amendment? I want to know which one you're talking about.
Before what year was it?
1868. 1871 is Dictionary Act. Yeah, Dictionary Act of 1871. You see how? You can't take the words in 1787 and use the same meaning as they use currently. If you do, you're going to get... Here's a good one for you. Facial overbreadth challenge to statute is exception to general rule that statutes are evaluated in light of situation and facts before the court. Test for constitutional facial overbreadth challenge is not whether hypothetical remote situations exist, but there is a significant possibility that the law will be unconstitutionally applied. There it is right there. Unconstitutionally applied. The Vehicle Code being unconstitutionally applied. The Public Salary Tax Act being unconstitutionally applied. The Social Security Act being unconstitutionally applied. Yes?
Facial overbreadth.
Yeah.
How close is it?
No, it's the law's too broad. Law's too broad. Page 45. Now 46. When facial overbreadth challenge to statute on basis of overbreadth and vagueness is raised, I forgot the D right there, court must first determine whether enactment reaches substantial amount of constitutionally protected conduct. State versus Lilburn. So, facial overbreadth challenge to statute on basis of overbreadth and vagueness is raised. So you've got to raise it. And how do you raise it? By judicial notices. And then you raise it by judicial notice, then you file a motion to dismiss based on vagueness. Very, very simple. That's a Montana case, 1994.
What page are you on? 46.
Here's a 1995 court case. See, remember the courts say these continuously, right on down the line. They never change. If statute enumerates persons or things to be affected by its provisions, there is an implied exclusion of other provisions. So, enumerates the first thing to be affected, and they say the Vehicle Code, for instance, it only applies to commercial activity. There's applied exclusion that applies to others. In fact, the law specifically says other people are exempted. You read it earlier in the Schmolke case. You know what I mean? Public Salary Tax Act of 1939. Whoops. Okay. Courts assume that legislature, when enacting statute, was aware of existing related laws and intended to maintain consistent body of rules. Forgot to cite on that one. That's when I must got a telephone call and got interrupted. I'm typing.
You know what year it is?
No,
1995.
probably.
That's what it says. You got it all.
Oh,
right?
and here, we have
On
a,
page 47.
Yeah, you got it? Okay.
yeah, we have a,
Now here's a good one, an old one. The power of the legislature is within its sphere unlimited, except as restricted by the Constitution. And the restriction of the legislative power is directed to the legislature and not to the people. The Constitution restricts the legislature, not the people. The people are supreme. People are sovereign. But you got to be a state citizen to be sovereign. That's a 1909 court case. Here's one you can use on the vehicle code or almost anything. General statutes are subordinate to specific legislation on the same subject. So, specific legislation, one section of the vehicle code talks about commercial activity, commercial trucks, and etc., how much weight and everything else. You follow me? So the whole thing is commercial in nature. They can't split the code up into commercial and non-commercial activity. That's what it says. The specific controls of general. Remember we talked about that the other day?
Yes, and as I've been sitting here listening to you, the same question keeps coming to me, which is, if you can guarantee that you can get the court to address the commercial aspect of the code, then why is anything else necessary, since the officer is not going to allege, if he's smart, commercial activity?
That's a good question. How are we going to get it? There's several different ways you can trick the officer into doing it. Officer, was I involved in any commercial activity the time you stopped me?
Right. Now, understanding that you're going to have tremendous objections.
Right.
You know?
But you file a judicial notice that the vehicle code is commercial in nature. File a judicial notice to the court and make the boundaries. And the court then argue that from that standpoint, then file a motion to dismiss right behind it.
Would that not make, at least theoretically, every one of these arguments, however good they might be, really extraneous or irrelevant?
We don't know where people are going to go. But no one argument can fit all. One size don't fit all. I know you just want to go to the heart of the matter and cut their throats.
Well, I mean, the aspect of commercialism comes as close to a one-size-fits-all as you're going to get.
Right. But that's 47. Here's a good one. Statutory interpretation is a question of law upon which appellate court exercises independent judgment where material facts are undisputed. The material facts is there was no evidence proving I was involved in a commercial activity. That's the material fact. It's undisputed. So what is the statute? Then you have to bring it, that's 1994. There's another one. Court's duty when interpreting statutes is to discern intent of the legislature. See, I do a lot on statutory construction, but most people don't want to do statutory construction because that goes right to the heart of the matter. And it's harder to teach you statutory construction than anything else. In fact, it's been harder for me. In interpreting a statute, Supreme Court gives operative words their common meaning unless there is something in the statute requiring a different interpretation. You go back to the statute and show what it meant. 1994. 48.
There's a whole big book in the law library, Canons of Statutory Construction.
Yeah. Judge's first duty in construing statute is to determine the meaning of the language used by the legislature. And we said earlier that when the legislature reenacted the 1994 and 1923 vehicle code, they knew the meaning of the intent at that time and just carried it forward. Court should not use inexactitude in drafting statute as excuse to impose personal values on legislative compromise. But fear of judicial usurpation should not compel courts always to adopt literal interpretation. And when context strongly suggests the alternative interpreting better advances the purpose of the legislation, there is no apparent reason for other interpretation. Judicial adoption of literal interpretation is the abdication of responsibility. 1994. So we can do a lot of statutory interpretation. I could spend 2 months just doing arguments on statutory interpretation, write a bunch of briefs on statutory interpretation on all the different words, showing how they're constructed. And the first guy who uses them, they can say, I stand on the pleadings. Duh. And here's a rule that all courts and all judges know and understand. Rule of ejusdem generis, which holds that where general words follow enumeration of particular classes of persons or things, general words will be construed as applicable only to persons or things with the same general nature or class as those enumerated. Applies whether specific words follow general words in a statute or vice versa. In either event, general term or category is restricted to those things which are similar to those which are enumerated specifically. Person means human being, corporation, trust, partnerships, etc. Those are all legal entities. Those are specific. So that person is an also legal entity. Write this down right now. Amjur, section 190, under taxation. Individuals are legal entities in all taxing statutes. Individuals are legal entities in all taxing statutes. That's in Amjur. There's a whole bunch of court cases, about 200 court cases there, Supreme Court case and everything else, stating that.
In all taxing statutes?
Right. Licensing is a taxing statute.
Legal entity is not restricted.
I'm not a legal entity. Here's another one. In determining legislative intent as to the scope of a statute, appellate court will examine the reasonableness of proposed interpretations and policy behind statutes so that all sections of applicable statute can be construed together. One section talks about commercial vehicles, the weight, how much they got to do it, and in order to make it reasonable, they all have to be the same. Driver's license applies the same thing. He's got to make the same stops and etc. So the whole thing is commercial in nature. There's several different ways to approach it if you want to approach them those ways. Legislative history and relevant policy interpreting statutes only when plain language of statute is ambiguous. Plain language is motor vehicle. That's ambiguous, has many multiple meanings. The word employee has multiple meanings. The word individual has multiple meanings. The word driver has multiple meanings. So you attack all the different aspects from different areas. Where statutes specify certain situations in which it is to apply, it must be construed to exclude from its operation situations not specified. And all I do is talk about driving in a commercial activity. So traveling is excluded from the vehicle code. Government employees, the 1939 Public Salary Tax Act applies to government employees and those who possess a Social Security number. Because if you go into the Social Security Act, it says that's the first time the term taxpayer is used in the Social Security Act. It says when the taxpayer owes one federal tax, he owes them all. In the Social Security Act, it says that. So,
That could be a clue.
yes, that could be a clue.
This one kind of goes along with what you said when you read a letter that you can get more out of what it doesn't say
Right.
than what it does say.
Yes. In addition to language of statute, court may consider its legislative history and background in interpreting a statute. I do a lot on statutory construction. Unconstitutional statutes. It's 11. So let's take a break right now, and we'll go for lunch for an hour and a half, then we'll come back, and there'll be no break this afternoon, because we have to be out of here at 4. We'll be back here at 1. Come back at 1. We'll adjourn now, and we'll come back at 1, and we have to be out of here at 4, so we're going to go non-stop. So get your coffee, have everything ready.
You're right to leave stuff here.
Yeah. Somebody's going to stay in the room. Dennis, you're going to stay here, aren't you? Okay, I'm talking still about statutes here. Welcome back after lunch, ladies and gentlemen. Remember, there's going to be no breaks today. If you need to take a quick run out the door, go ahead. Unconstitutional statutes. Turn these down all the way and turn those up back there and see how it works.
Or we had the side ones on earlier. Yeah. Can you come light and right?
Yeah.
The side lights a little brighter, they're kind of dim. Right there you go.
Turn those up a little bit and turn the others down. Turn those up higher. And then turn the others off. Now turn the other side lights higher.
Okay.
No, we need a little more light. Turn these up just there. A little bit more, a little more. Little more. Little more. That's good right there. Perfect. Thank you. Statute which on its face appears to be overbroad may still be held constitutional is given a limited construction by the appellate court. The Vehicle Code is constitutional as applied to commercial activity, but it's not constitutional as applied to a citizen traveling. So that's a limited construction. It's the same way with the Public Salary Tax Act or anything else, you know what I mean? If it's like in David's case here, where they terminated him because he wasn't a U.S. citizen, the law is unconstitutional. It can be ruled unconstitutional as being overboard. But if they just limit it to a specific application, you follow me? Okay. Civil as well as criminal statutes are subject to void for vagueness examination. Thus, the premise of a statutory construction is that the court must ascertain the legislative intent of the meanings and definitions of the words used in the statute. If the words used in the statute have two meanings which are not compatible, the court must clarify the definition, that is the legislative intent, and rule that any other use or interpretation is in void. So that gives you your motor vehicle or Public Salary Tax Act or anything else. You know what I mean? Cases involving constitutional deprivations are subject to the general rule that remedy should be tailored to the injury suffered. This is when you are the plaintiff in an issue. You follow me? Like in your case, David, where you're the plaintiff. You follow me? They were depriving you of the right to work. That's a constitutional deprivation of right of liberty to work and feed your family. So when you sue your workplace, you know, 1995. See, and when you use constitutional deprivation, key thing, you never sue any government or any private company for violation of the statute, because the government can always come back and claim sovereign immunity. But there's no sovereign immunity when you use a constitutional deprivation. They cannot claim sovereign immunity. Got some court cases on that as we go through here. So always use constitutional deprivation. To mount a successful challenge of facial constitutionality, defendant must show that statute poses present and fatal conflict with constitutional principles. Defendant cannot prevail by simply suggesting hypothetical situations in which constitutional problems may arise. They've got to be actually present. In other words, you've got to be injured. I have been injured by this. I got a traffic ticket. I was fined $300. I spent 4 months in jail. You follow me? Now you go back and challenge the constitutionality of statute in a lawsuit. See, that's 1995. Oops. This thing likes to jump around on me. Under Overbreadth doctrine, litigants may challenge statute not because their own rights of free expression are violated, because the very existence of Overbroad statute may cause others not before the court to refrain from constitutionally protected expression. I can think of 3 instances off the top of my head to use this particular quote. One, under state citizenship, your right to have political status as the same as George Washington. That's a political argument. You know what I mean? That's an overbreadth. Your elector versus a voter, not giving you the right to be an elector is 2. You know what I mean? And traveling, right to refrain from constitutionally protected expression. Your right to travel in interstate or intrastate, either case, maybe, whichever way. That's a 1995 court case. I can't remember. Elector. I just move on, you know what I mean? The whole doctrine of Brown versus State of Maryland has been doubted, and the right of states to regulate their own internal commerce and to tax every species of property within their own jurisdiction. Name more. Concurrent power of states over subject of commerce now firmly established by opinions of majority of justices of the Supreme Court of the United States. That's 1854. Overruled by on another point in People v. 1868. So, in Brown versus State of Maryland, which is a court case that talks basically that the federal government was supreme. And they, in 1854, they said no. The states were not supreme. The federal government was not supreme. They all the way, in the Bidwell case also. Bidwell's on the BBS. 1905, I think. By well-settled rules of construction, the right of state to regulate commerce is concurrent with that of Congress, with understanding always that all state regulations, inconsistent with those of the federal government on this subject, must give way. If you notice, the same court case, 1854. Now, this court case was talking about commercial intra-state commerce, not intra, not within the state, but it was crossing state lines. And they use it right now in current law. They use this court case, never distinguishing it, and that's your job to distinguish it out. Say, yes, that case is 100% correct. That's another one. This is the one I'm looking for right here. Commerce, in the sense which the word is used in the Constitution, is coextensive in its meanings with intercourse. Intercourse means traveling, doing business, operating within. You know what I mean? But they've taken this term, commerce, and stretch it from interstate, that's what it used to be, to include intrastate. And the Lucas decision last year down in San Antonio, United States Supreme Court, reverted back and said, no, that was the Gun School Safety Act. You know what I mean? It didn't involve interstate commerce. And they're reversing their decision. Supreme Court's reversing, going back to the original.
So commerce means intercourse, that means you get screwed either way.
Yes. See here. The term commerce as employed in the U.S. Constitution, Article 1, Section 8, is not limited to the exchange of commodities only, but includes as well intercourse with foreign nations, between states, and includes transportation of passengers. Commercial activity, passengers. See, it's all commercial. It's all commercial. Now we're going to go to my favorite area, judges. Okay. There's an old court case of 1995. Okay. Once it has been demonstrated that the trial judge's conduct or remarks constitute comment on the evidence, the reviewing court will presume comments were prejudicial. How do you use that court case? You ask the judge right up front, Your Honor, are you commenting on the evidence? He says, well, you submit an affidavit here, you know what I mean? He said, I don't believe this affidavit. Oh, you're commenting on the evidence, Your Honor? Judge can't comment on the evidence. He can't do anything if you know how to put him in a box. That's one of the boxes you can put him in. Start putting his boundary lines around him. See? If he comments, you put a judicial notice in. He says, well, I don't believe this judicial notice. Oh, you're commenting on my evidence, Your Honor? You see how you... Don't be afraid to ask. You walk him into the whole program. You follow me?
Richard?
Yeah.
How would a judge not comment on something like a judicial notice on the word person and still rule on it? Because, I mean, there has to be some...
No, the prosecution's supposed to give him arguments. You follow me?
Well, I can tell you in Santa Barbara that wasn't always the case.
I know.
That prejudice, you didn't know that. That wasn't my case.
See, trial judge has prerogative and at times duty of eliciting facts he deems necessary to clear presentation of issues. And to that end, judge may question witnesses so long as he preserves attitude of neutrality. He can't assume the position of the prosecutor. And you bring that up to him, and you say right up front, Your Honor, are you acting in lieu of the prosecutor? And he's going to say no. Then, Your Honor, you can't say anything. You know what I mean? Where's the prosecutor? And here's another good one. A judge may not actually take the stand. He may not interject testimony-like statements into the proceeding, which would put him in essentially the same position as a witness. If he starts commenting or making statements like a witness would, then you turn around, Your Honor, those are statements made by a witness. Would you, the court like to take its robe off and come up on a witness stand so I can cross-examine you? Watch how quick he shuts up. Because now you've caught him. Caught him. That's Swenson. Error for judge to contradict witness or defendant. Judge The judge cannot contradict you. You know what I mean? He says, I don't believe you. You know what I mean? I don't believe this affidavit's true. He's contradicting you. It's not his job to contradict you. And it was reversed. Error for judge to contradict defendant or witness. Your Honor, are you contradicting me? My statements? You put them in the witness stand. Ask the specific questions. You know, that's what these court cases are all about. Showing you what the courts rule on, and show you how to ask. See, another one. Conviction reversed when trial judge said he was sure that the defendant had violated the law and was lying. That's a witness's statement.
That's a presumption also, isn't it?
Yeah, he was sure. That's, you know what I mean? Here's another one. If judges' relationships or state of mind come within statutory definition, the judge must recuse himself. All of the statutes are premised on the constitutional right to have one case heard by a neutral and detached judge. And there's not one judge in this nation who's neutral and detached. But you have to bring it up. A judge who has a driver's license in his pocket cannot sit on a no driver's license case. A judge who pays income tax cannot sit on an income tax case. Because he's biased. If he thinks he's got to do it, so should you. And I've heard many U.S. attorneys, Your Honor, everybody should pay their fair share. And the judge say, yeah, everybody should pay their fair share. Now he's already... because
Goes right in there, they can have their salary diminished.
Right.
So when you ask the judge if he has a driver's license, and he says yes, you then move to have him dismissed or something?
Yeah. You move immediately. Your Honor, would you like to voluntarily recuse yourself, or shall I file appropriate paperwork? In California, you're allowed to recuse the judge one time under 170.6. You can recuse every judge in the nation, all 80,000 judges, under 170.3. See, 170.6 you're allowed once. But 170.3 you can, or 170.1 or 170.0, you can do every judge in the whole nation. Makes no difference.
What if it's there's a jury and the juries have driver's license?
We never have juries.
I mean,
Hey, we never have juries. That's 100% conviction rate. Anybody has a jury, don't talk to me.
You'd like to have a judge.
I got no use for anybody who has a jury. Is that clear enough? Because you can't convince 12 people who got driver's license that you don't need a driver's license. You may be able to argue one judge, but you're not going to convince 12. Yes?
Is this particular Site 409 U.S., is that mandatory authority for California judges?
Yeah, 170.6, read it. The civil code. Reversal is required in cases alleging gender bias where it was reasonably clear that trial judge entertained preconceptions about parties because of their gender, which made it impossible for parties to receive fair trial. 1995. How did you use that? Very easily. Bias. Preconceptions. Your Honor, is the court's opinion, do you have a preconception that everybody in California is a U.S. citizen? If he says yes, you got him. If he says, oh no, then do you believe that George Washington was a state citizen? He was a citizen of Virginia. He wasn't a U.S. citizen. Do you believe that, Your Honor? Do you believe that same political status exists today? Now you walked him right into it. It's damned if he does and damned if he don't. It's just how you ask the questions. You walk him into it, step by step. If he says, no, oh, you're believing that the federal government's permitted to commit genocide. Is that what you're telling me? Be able to walk them right into these step by step into these things. And you can box the judge in. See, then you can say, I can't receive fair trial here. Here's another one on the same thing. where average person could well entertain doubt whether a trial judge was impartial. Appellate courts are not required to speculate whether judicial gender bias is actual or merely apparent, or whether the result would have been the same if evidence had been impartially considered and dispassionately decided, but should reverse judgment and remand matter to a different judge for a new trial on all issues. So you've got to be consistent, you know what I mean? And that court case is 1995 case. Catchpole again. Now here's one we just talked about. Listen to what the court said. Every judge is bound to know the history and the leading traits which enter into the history of the country where he presides. Your Honor, at the time California Constitution of 1849 was accepted by Congress, everyone became a California citizen. There was no such thing as a U.S. citizen at that time. Do you understand that, Your Honor? Because now you're putting them all like... Yes. You're putting them in there. And he says, well, that's true. Didn't you believe that political status still exists today? If he says no, he shoots himself with this hand. If he says yes, he shoots himself with the other hand. You have to be able to know how to ask these questions. Then you can bring up this court case. Your Honor, you're supposed to know the history of this nation, this country, history of California. You don't know it? Then, I'm sorry, we'll have to get a different judge. Find somebody who knows. You see how you do it? That's how you do it. Here's the next one. Courts are bound to take notice of matters of public history affecting the whole people. The whole nation was predicated on the fact of state citizenship and states' rights. You saying that the federal government has the right to commit genocide against state citizens and steal their political status? Is that what the court's telling me, Your Honor? I don't quite understand. I want to clarify it for the record. I always say you like to clarify it for the record. You know what I mean? That puts them in a quandary, you know what I mean? And then if he doesn't want to go there, you go to the next court case down. The history of the state is a matter which courts will take judicial notice. Now you force them to take judicial notice. There was no such thing as... You see, you just walk them right down the lines. You have to, you see, that's a 1917 court case, California Supreme Court. And under rules of stare decisis, he's got to recognize it. Here's another one, same thing. 1930, the Supreme Court takes judicial notice of public history. Here's a unique one. Change the pace a little bit. As a matter of strict right, either party litigant has the right to the unbiased opinion of the trial judge based upon legal evidence. Where's the evidence? Remember, we talked about that at the very start. We're going to talk about it numerous times. Where's the evidence? What legal evidence do you have that I'm a person? What legal evidence do you have that I have a motor vehicle? What legal evidence that you have that I was driving? Driving is a vague and ambiguous term. Briefs and rebuttals. Here's one. There's a whole bunch of these I've got. Opinion is not authority for proposition not considered. The prosecution writes a rebuttal brief to you, or you're up on appeal or whatever. And they'll quote a court case that talks about drunk driving. And you're talking about state citizenship. Drunk driving has nothing to do with state citizenship traveling. So that case is distinguished. It's not authority. And you move to strike that specific case. And you write up a brief. It's called a motion to strike. Write that down. Motion to strike. Motion to strike, and you list each one of their court cases down and why it should be stricken. When you wind up, he ain't got nothing left. Then you file a second motion to strike his brief because he ain't got nothing left. Then, after the judge agrees with you that to strike them, then you turn around and ask the court for sanctions for filing a frivolous brief. Always ask the court for sanctions. They may not give them to you, but you can always ask. That makes the district attorney very upset because you're always asking for sanctions. Here's a bunch more here. Judicial decisions are not authority for propositions not considered therein. Did that case talk about state citizens traveling, or did it talk about commercial 18-wheelers? 18-wheelers has nothing to do with me. I'm a state citizen and I'm traveling. Case distinguished. You follow me? Look at all those court cases. Got a bunch of other new ones up here too. Evidence on part of the defendant to disprove what the plaintiff has failed to allege and prove, and which was necessary to sustain his cause of action, is properly excluded as immaterial. So if they don't bring something up, you don't have to disprove it. That's what the court's basically saying. Evidence which is not pertinent to the issues raised by the pleadings is immaterial, and allowing its introduction constitute error. You can move to strike his pleadings based on this argument right here, 1947. His evidence that I was driving is a court brief. There's no personal knowledge of the district attorney. You know what I mean? The officer has no personal knowledge of what a motor vehicle is. He has no personal knowledge of what my political status is. So all this should be stricken. You know what I mean? There it is right there. Not pertinent to the issue, is immaterial, and therefore it should be stricken. Court should admit no evidence that is not material, and by admitting evidence over objection, it is necessarily determined that it is material. But you have to object to it of materiality. The rejection of immaterial evidence does not constitute error. Here's that one we talked about earlier. People versus Roeder held that their mandatory presumption criminal trials are unconstitutional. Is the court taking mandatory presumption that I'm a U.S. citizen?
In the tax court, they certainly are.
Well, it's, where's the evidence? You know what I mean? You're in tax court, you admitted it. We never go to tax court. Tax court is voluntary. You have to admit to being a taxpayer and subject to the code to get into tax court. In criminal trials, no presumptions are permitted as to the elements of any alleged offense. A state must prove every ingredient of an offense beyond a reasonable doubt and may not shift the burden of proof to the defendant. That's the United States Supreme Court. No presumptions are permitted, say, for any alleged offense. They've got to prove every single element. But you've got to get in and challenge them. Make them prove every element. Don't let them slide by. The first element, what's the first element they got to prove in any court trial? That they got standing to be there. That's the first element. That they have standing. If they don't have standing, they can't be there. That's the first element. The next element they got to prove is that I'm a person that's defined within the code. And if they get over that hurdle, then they got to prove I was involved in an activity being regulated. You got a lot of sharp hurdles for them to jump over with spikes on the other end. You know what I mean? So when they jump over, they're going to fall on those spikes. That's the principle of what we're trying to do here today, is teach you how to use some of these court cases that are, you know what I mean? That's People versus Rotor again. Here. The opposing party need only to overcome any of the presumptions by merely to raise a reasonable doubt as to the existence of the presumed fact. How does that go along? Very simply. How do you do it? By the presumed fact. What is the presumed fact? The presumed fact is that I was driving in commercial activity. That's the presumed fact. There's no evidence.
Rebut the presumed fact?
You rebut it. All you have to do is raise a reasonable doubt. And what's the reasonable doubt? I wasn't doing the activity. The officer did not understand what commercial activity is. Officer doesn't understand what the word traffic means. It means commercial activity. And the judges will rule that the officer is incompetent to testify if you do it right. And if the officer is incompetent to testify, then he has to move to strike the ticket right there, the citation, because if he's incompetent to testify as to what he knows, then how can he write a citation?
So, by asking the officer if he knows what traffic means?
It is personal knowledge.
Personal knowledge.
Remember we talked about that earlier this morning. Here's a good one. This is what they use against you, right here. There is no presumption that the United States citizen knows the laws of a foreign country. You're in California, you're alien to California. Resident means alien. So you're not, as a U.S. citizen, you're not supposed to know the laws. You're supposed to just do as you're told.
What foreign country are they referring to?
Whatever country, that was a Germany, I think, German case. But California is a foreign country as it relates to Washington, D.C. There's
But the state of California is not.
state, depends on which state of California you're talking about. Which the one defined in 1849 or the one in 1940? Which one are you talking about? Which one are you talking about?
The one defined in 1879 is the one that has established.
Okay, you're talking about 1879. Then it's not a foreign country. If I'm talking about 1849, it is a foreign country.
But the one of 1849 doesn't have all these commercial traffic laws.
Okay. Presumptions are indulged to supply the absence of facts, but never against ascertained and established facts. Are indulged to supply absence of facts. So they use a presumption in criminal trial, presuming you have a motor vehicle right off the bat. The officer made a presumption. Officer, did you presume that my automobile was a motor vehicle? Yes, I did. Thank you. Do you have personal knowledge what a motor vehicle is?
Yes, 268.
268 is commercial activity. Was I involved in commercial activity? Was I driving an 18-wheeler or a school bus or something like that?
Hey, you're right, exactly. Put that man in jail.
You see what I'm saying? Know the argument.
Richard,
Yeah.
a 12500A is obviously criminal, but how about just a speeding violation? Is that civil or criminal? And if it's civil,
It's both.
so
It's a civil infraction with penal penalties.
can they use presumption?
No, because they're taking property from you. No party can claim the right of a presumption against his own admission under oath. So they got to. The officer up there, he's made his presumptions. You know what I mean? Now you got to prove that his presumptions are wrong. he can't use presumptions. Only admission under oath. He admitted, he signed that ticket under penalties of perjury. Now that's an oath. Now he's got to know what the word traffic, what driver, what a motor vehicle is, or else it's a presumption. And it's a rebuttable presumption. Presumptions are merely creatures of the law. Here's one they use all the time on us, consistently. A presumption cannot be based upon a presumption. They do. How do they do that? How do they base a presumption on a presumption? Right off the bat. They presume you're a U.S. citizen, and they presume, since you are a U.S. citizen, you are here in this state under the protection of Interstate Commerce Clause, and that can be regulated, controlled, and taxed, and they presume you have a motor vehicle. It's all presumed all the way back to the original thing. They presume you're a U.S. citizen, and they presume you got it right there. So you got to rebut those presumptions. And you say, Your Honor, you can't base a presumption upon a presumption. The judge's going to look at you and say, what are you talking about? Well, they're presuming that I'm a U.S. citizen under the protection of the Interstate Commerce Clause. That's all presumptions. Where's the evidence? Remember the term, where's the evidence? 3 words, very important. Where's the evidence? Here's a good one. The presumption of law is that a condition of things once shown to exist continues until some charge is made to appear. Some change, that should be changed, is made to appear. So, state citizenship existed. Now, in 1849, 1850, state citizenship, 1860, state citizenship existed. It's presumed that that still exists. Is that correct? No, you say state citizenship doesn't exist. Oh, you're admitting to advocating genocide of the sovereign we the people. Is that what you're telling me, Your Honor? Don't be afraid. Ask it in the question, you know what I mean? For the record, preface everything you're going to say. For the record, Your Honor, I don't quite understand. I'd like to clarify that point. Are you telling me that it's okay if the federal government commits genocide against state citizens and abolish the political class? Same as the Contras do and the Russian NKV did, you know what I mean, etc. Are you saying this is okay in this country, in this courtroom? For the record, you know what I mean?
Contempt are, please. Might be a good time.
Contempt is when you slander or impugn the integrity of the court, not when you ask a question. You can never get contempt if you're asking a question. No matter what the question is, you can never be held in contempt to clarify a point. You're not, yes.
Stupid, Your Honor, would that be contempt?
Pardon?
That would be a question, but that would be contempt. Are you stupid, Your Honor?
That would be contempt. I'd like the record to reflect, and I want the court to take judicial notice, and the prosecutor and everybody in this courtroom take judicial notice that the judge does not understand the history of this state. That's like calling him stupid, but without calling him stupid. It's the words used. Okay? It's how you use the words that's important.
So you can verbally state a judicial notice like that?
Sure, if it comes up right out in a hurry, you know what I mean? You don't like to do it, but you can. If something comes up, you can do it right off the top. You know what I mean? You don't know where the court's going. I can't predict what's in your mind. I can't predict what's her mind or his mind. But if it comes up, you can ask the court to take judicial notice of it, if you got the facts in your head. That's what these briefs, these court cites are about, to establish the facts in your head, so you can, when you're in court and some subject matter comes up, then you can properly come up with a court cite. You know what I mean? A status once established is presumed by law to remain until the contrary appears. Overruled by Vance, that was a different, you know what I mean? For this guy here. This was talking about political status argument there. It was overruled for other reasons.
Would that apply to having been a U.S. citizen once?
Right, until it's presumed. That's why you do a declaration of citizenship. Here's what's important. One, we always ask for it. Where neither party requests a trial court to make findings of fact and conclusions of law, Court of Appeals must presume that trial court found every fact necessary to support judgment. Judgment must be sustained if any reasonable construction of evidence justifies it. You got an error there. I don't know where you got an error in yours. That's Sutherland's. Yeah.
Make a request for findings of fact and conclusions of
To the
law.
judge. You can do it two ways. You can do it orally or by motion. I always request them tell people do by writing because people forget if they're doing it by mind. Yes.
But that doesn't apply in the municipal court. Findings of fact. The legislature has relieved them of that responsibility.
But see, you can put it back on them. Your Honor, I like findings of fact, conclusion, and law. We don't have to do that anymore. But it's necessary for appeal purposes, Your Honor. And failure to do so is a denial of due process. So you come right back and he'll do it. You know what I mean? But you got to force him to do it. Every time he says something, always say it's a denial of due process. No matter what he says, it's a denial of due process. The Constitution of a state is the fundamental law of the state. If you notice right here, it says the Constitution of the state is the fundamental law of the state. Small s, capital S. This state is a landmass. Capital S is a corporation created by the state constitution. The state government is a corporation. The small s can have citizens, capital S cannot have citizens. That's a corporation. People, this is a landmass. Okay?
How does a corporate state have sovereign immunity?
Because they have sovereign immunity against aliens. You knew that too, didn't you?
Oh, yeah.
Okay. I'm going to do something here. Okay, you see that screen there? That's a small s state. Okay? That consists of land, people, and government. All combined, okay? Now this writing on there is the capital S state that occupies the land. And you can eliminate the capital S, but the small s still remains. And the case that quotes that very plainly is Texas versus White. They go in there and explain. Consists and occupies. Consists and occupies. Consists and occupies.
Who's Texas versus?
Texas versus White. That's your landmass. There's your capital S government, small s government, small s state. Capital S state, small s state. So you understand the distinction. The capital S state can be removed because it only merely occupies. Key word being occupied. The small s state consists of. It's part of it. I usually do it on a chalkboard.
If they eliminate the small s state, that would also eliminate the capital S state, isn't
Right,
it? Aren't
because
the two of the...
there's nothing to occupy.
Yeah, the capital S states must have...
Year that case was?
Ware versus Halting, $3. I think it's 1794. And it's still valid today. Now here's one most people don't understand. I've been trying to tell people about this for a long time. An action under a mandamus statute must be won against the author in his personal capacity and not against the office, i.e. the sovereign. The sovereign cannot make a mistake. The person occupying the office can. So if you go and do a writ of mandamus against the DMV, you do it against the person who was there. You know what I mean? Your agent. You follow me? Who denied you? Who signed the paper denying you? You don't do it against the Department of Motor Vehicles. You do it against him because it's an abuse of discretion. He doesn't have that right. It's the same way with a judge. If you want to do a writ of mandamus against a judge because he refused to take judicial notice that you filed, you know what I mean? You do a writ of mandamus against the judge because it's an abuse of discretion to refuse to take judicial notice of a case that's important to your defense. Got a court case on that, someplace along here. Here's another one, 1995. There is no presumption that exclusion of evidence which was properly admissible and relevant to issue on the case is harmless. There's no presumption. They have to admit every piece of admissible evidence. If they deny you, then falls within these guidelines. It's exclusion of evidence. We've got court cases someplace along the line here we're going to see where the judge cannot exclude evidence that's pertinent to your defense. Yes. Listen to what the court said. This, I think, is 93 case. I'm not sure. Right to equal protection of the law is guaranteed to state citizens by means of due process clause of state constitution. Right to equal protection of the law is guaranteed to state citizens by means of due process clause of state constitution. I think that's 1995. Court case out of Denver, Colorado. I didn't put the date on that. 1993. Now here we got California and Arizona. And this is very important. Bail set at figure higher than amount reasonably calculated. Where am I? Got an error there someplace. Go down to the next one, same thing. This is the most important one right here. As applied to statutory surcharge, amount of bail must be same regardless of any assessment that is included in bail amount in order not to be deemed unconstitutionally excessive. An assessment must be part of an amount of bail sufficient to secure attendance of defendant in court. Adding assessment to sufficient bail amount and then calling the joint sum reasonable bail violates Constitution. They do that all the time in California right now. They just got overturned in Arizona. California has a 170% assessment charge. If your fine is $10, your bail is set at $27 because added on top. That's illegal. If your bail is $10, you walk out for $10. Or if it's $100, like to these poor guys in drunk driving cases, I've seen them. The guy says, well, the judge set my bail at $1,500. He said, I got out cheap. Then he walked up the window, found out there was 170% added to it. It's almost $5,000 in.
How would you argue that?
Well, it's surcharge. Arguing it that the surcharge is not part of the bail. Yeah, it's got the court case, 1994, right here. I think there's only 4 states that have a surcharge, and Arizona just lost theirs. 1994. If jury instructions properly and fairly state law as applied to facts in a case, if jury could not reasonably have been misled by them, instructions do not constitute reversible error, although they may in some small way were erroneous. In some small way, erroneous. It should be a Y. You like jury instructions, but I do use jury instructions. I'll tell you how to use your jury instructions. You go into Calgic or Baji. Calgic or Baji, jury instructions. And read the jury instructions. And when you read your jury instructions, you build your argument based on a jury instruction.
What book are you looking at?
Calgic, C-A-L-J-I-C.
Or what was the other?
Baji, B-A-J-I. I go ahead and read them and come up with good arguments based on those principles involved in that specific issue. Okay? Okay, here's one important one for you people. Review of trial court's action is inappropriate when action has not been listed as an issue on appeal and no argument or authority on issue is contained in brief on appeal. You always lay your foundation at the trial level, consistently. You lay your foundational arguments, you know what I mean, objection, etc. Then when you go up on your appeal brief, then at that time you lay an argument, get a court case authority for what you want to say. There's only one authority. That's all you need. You have to have the argument set at trial level and bring it up on appeal. And you've got to have an authority on the issue contained in a brief on appeal. I've seen many appeal briefs where attorneys have written them that they go in there and argue something and never have any authority for it. Here's a good one. Review of post-conviction proceeding is at law. See, in other words, at the common law, it's post-conviction. It's important that you do. You can appeal after you've been convicted. You can go through an appeal process. And you can do your appeal process for 5 years if you know how to do it. I'm teaching Steve how to do it right now. You go up on your appeal, first step. Write it down. Appeal. Then you do a writ of review to the upper court. Then you do a writ of review to the Supreme Court. And that's denied. Then you go back and do a habeas corpus at the Superior Court. Then you redo a have at the Appellate Court. Then you redo the have at the Supreme Court. You still lose. Then you go back and do a have at the District Court and work your way up through the Federal Circuit. If you lose there, then you go back and do a coram nobis, N-O-B-I-S. C-O-R-U-M, nobis. Coram nobis goes back to the trial court, and that's to correct errors in the record. Then once they correct the errors in the record, then you go back up on appeal again. You start the process all over again. Then there's a couple more steps you can do if you want to.
You couldn't afford to do this if you were paying attorneys, but pro se, you could take as much time as you
Oh,
want.
pro se, we're not pro se. That's for slaves. We're pro per. See, let everybody, so we'll know what, so he'll understand, everybody else will too. Pro se means you're acting as your own attorney with the permission of the court. Pro per, or propria persona, means you're acting or prosecuting in your own right without the permission of the court. And the courts recognize that. You got to hammer them a little bit, but they will recognize, right, Steve?
I've never been challenged.
They know. They know. There's a difference. Remember we were talking earlier. Erroneous admission of evidence may not be raised on appeal absent timely objection stating grounds for objection. Remember I told you we give you objections right up front so you have plenty of different objections. You always do your objections. No matter what they say, object on the grounds of immateriality, no foundation laid, or whatever. Assumes facts not in evidence. That's the best one. No foundation, assumes facts not in evidence. Those are the two best. You can run them together, either one or the other, or both together. Because that shuts them off, okay? There's another one on the same lines. Employee who presented no admissible evidence indicating that reasonable value of his service exceeded his base salary was not entitled to recover money from his employer under doctrine of quantum merit. So he wanted additional money, but he didn't bring any evidence in. There was no evidence and no issues brought in. So he was denied. See, there's no admissible evidence. How would you get admissible evidence? Well, if I would have worked here all year long, I would have made $30,000. Right now, because I did not work and I was not able to work, I'm $30,000 in the hole. So therefore, that's $60,000 I need. That's the way you bring it in. You like that argument, Steve?
Love it.
Here's another one saying the same thing. Point not raised in trial court cannot be raised for the first time on appeal. If you don't bring it up at the trial court, you can't bring it up on appeal. It's got to be consistent, you know what I mean, with your arguments. And for those people who do want a jury trial, you have to file a motion in limine. I recommend highly against it, but those who do want a jury trial, when motion in limine does not cover basis of objection raised on appeal, and where there is no objective evidence when it was offered at trial, admission of evidence may not be challenged on appeal, unless fundamental error was involved. So I tell people, motion in limine is really easy to make, but you've got to be able to understand. Okay? Oops, I got a mistake there. Denial of motion in limine preserves objection to evidence. Here's a good one. I like this one because it involves several different issues, multiple ways. Statute that either compels or forbids an act violates due process clause of state and federal constitution. If people of common intelligence must necessarily guess at meaning of the statute and differ as to its application. You see where it comes from? Employee, driver, motor vehicle, code enforcement person, you name it, can all fit within this one little argument here. So this is, you can challenge the statute based on this vague and ambiguous. It's violating due process because it has multiple meanings and they didn't define what the words mean. And make them define what the words mean. Here's another new one for you. Due process requires that state bear burden of persuasion of every essential element of crime beyond reasonable doubt. See what it says? Due process requires that the state bear burden of persuasion of every essential element of the crime beyond reasonable doubt. What is the first element they got to prove? You're driving, you're cited for a 12500 no driver's license. What's the first element they got to prove?
You're a driver.
No, you're a person. First they got to prove you're a person. Then they had to prove you got a motor vehicle. Then they got to prove you're driving. Then they got to prove you're involved in commercial activity. Then they got to prove that you were a U.S. citizen. Then there's a whole bunch of different things they got to prove. Every single element. Don't let them get away with anything. If you don't force them to prove it, they're just going to go on based on presumptions. This is the way they're going to do. They're going to always base themselves on presumption if you don't prove it. But you have to prove, make them prove every single element. It's important. Because if they don't prove it, they're going to get away with murder. And what is murder? Your pocketbook. Fact of payment does not establish by itself an account stated, but payment rendered, that's supposed to be, under protest or intent to negotiate at some future time does establish account stated. How do you use this? Very easy. Social Security account number. Federal account number as security for the federal debt. Social Security, your account. If you notice on top of any letters, the FTB or the IRS or your state tax authority sends you, they always say account number at the top of it. They know what they're doing. They're very intelligent. How come we didn't know all this? But it's right there.
We didn't know how to read.
It's all in the law. Now here's a good one that really upsets judges, if you know how to use it. And I like to upset judges. District attorney, they're too easy to upset. They're a big nothing. They're easy to upset. I wish one of them was here right now today. Your son. Listen what the court said. An Alfred plea is a plea of guilty by the defendant in order to take advantage of a plea bargain. Alfred plea is valid and under Missouri law is treated as guilty plea even though the defendant denies commission of underlying crime. Say the DA says, well, if you plead guilty, we'll fine you $20 and let you go home. Okay, I'll plead and take an Alfred plea. Because you already filed all your paperwork by then. You follow me? Now you can go up on appeal. Under an Alfred plea here, you can appeal. If you plead guilty, you cannot appeal from a guilty plea. You cannot appeal from a no contendere plea. But an Alfred plea denies you committed the crime. And it's valid in every state in the union. We've used it here in Ventura. And the district attorney says, I don't know what an Alfred plea is. And the judge says, I think I read about that. Let me go in the back room. And a few minutes later he comes out. He says, yeah, we can do an Alfred plea here. Yes.
What does that mean in parentheses? C period, A period?
What?
C period, A period in parentheses?
Court of Appeals. That's a federal court case in Missouri. So all federal courts take an Alfred plea. That's saying, I'm guilty for sentencing purposes only, not for admitting guilt. And they don't like that because now it's going to, they give you a small fine, and you've gotten rid of the jury trial. Now they're going to take them to, it's cost them $100,000. They're going up on appeal. Here's another one. This is Idaho. The other one is Missouri. Here's Idaho. Alfred plea. Defendant pleads guilty but does not admit committing underlying offense. So there's no civil liability attached to it. Now you can appeal. How do you appeal? Because you've laid all your proper foundation, did your judicial notices, your motions to dismiss and everything else, you follow me? And you're saying, I didn't commit the crime. I'm going to take it up on appeal, prove I didn't commit it based on the paperwork that's already submitted. And they can't rebut it if you set it up properly. Okay. There's you've heard a lot about pleas and abatements. File an abatement with the court. You know what I mean? File an abatement here, abatement there. You know, some of the patriots out there are doing it. What is a plea and abatement? A plea and abatement is reserved for matters which defeat action on basis other than its merits. You don't challenge, it doesn't go to the issue of whether you did or did not commit the crime. It's whether the law was properly applied or whether you had an account or whatever. You know what I mean? That's what a plea and abatement is. Non-assumption. The basic thing is non-assumption. Okay?
Can you use that along with the demur?
Yes. You can use it attached to it. You could be appeal of abatement / demur. Plea of abatement in the nature of a demur.
Can you do one and then the other if the first one didn't fly?
Yeah. Because you're only allowed one demur, and you can do 3 or 4 different plea abatements based on different subjects. Here's a good one on jury instructions. If party is dissatisfied with an instruction, it is that party's duty to propose appropriate instruction. And if court fails to give instruction, take exception to that failure. If party does not propose an appropriate instruction, it cannot complain about court's failure to give it. Principle of law. Your Honor, I move to strike the prosecution's brief as being frivolous because all the cases are distinguished and are off point. They don't involve what we're talking about here, the issue of state citizenship traveling. They talk about drunk driving and everything else. And I like appropriate sanctions, and you've got to ask for it. That's what this court is telling you. You cannot complain about failure to give it. You've got to ask for it, and if the court doesn't give it, then you can complain about it. But if you don't ask for it, you can't get it. You've always got to complain. You've got to ask before you can complain about it. Here's another good one. Trial court abuses its discretion when its decision is manifestly unreasonable or based upon untenable grounds. Manifestly unreasonable, that's what most of it is right there. Because there was no evidence before the court. The court established no evidence whatsoever. There was no evidence. So the court was unreasonable. It's arbitrary and showed judicial bias by finding me guilty. The court was not impartial. You see how that court case would go. Here's Bryson versus State. Is this the one you were talking about? 876p second 240. It is improper for prosecutor to express his personal opinion of the guilt of the accused. He's got to prove it. Your Honor, I moved for a new trial based on the prosecutor's obvious bias in this matter, or move to sanction prosecutor by dismissal. See? To express his personal opinion of the guilt of the accused. Just because the prosecutor's got a driver's license and I don't, he thinks I'm guilty. Mr. Prosecutor, because I don't have a driver's license, you have a driver's license, you think I'm guilty of this charge, isn't that correct? Yes, thank you. That's your personal opinion, thank you. You walk them into it. You see how you walk them into each specific thing. IRS case. You're being prosecuted by a tax matter, you know what I mean? Mr. State's Attorney, you think I'm guilty because I didn't pay, you think I didn't pay my taxes. Is that what you think? That's your personal opinion. It's your personal opinion that everybody should pay their fair share? Yes. Thank you. Yes.
To always interact with the judge?
No, you can address the prosecutor directly. No problem. Because he'll address you. You know what I mean? He can talk to you, you can talk to him. But you see how it is?
Now, when he does that, what would you do? Bring it to the judge's attention and say the prosecutor is just...
No, you just shut up. And let it go on record, and after everything's done with and the trial's over with, then you go up on appeal on this one issue. You know what I mean? That's an appealable issue.
Do you feel that I'm guilty for not having a driver's license because you do have one?
Right. That's your personal opinion?
Judge, for the record, I'd like to clarify that, you give notice to the court.
We'll just get it on the record.
Okay, here's one that's very important to everybody here. I holler at everybody, make it very nasty about it. Notice to Attorney General when constitutionality of any statute is challenged on appeal is required on appeal as well as trial level. Anytime you challenge the validity of the vehicle code, you must include the Attorney General, Dan Lundgren.
Is that an administrative lawsuit?
Administrative law also. You've always got to include.
Maybe that's why they did one.
The notice to Attorney General. And it's even at the trial level. So most people do. Most attorneys don't even know this. So when you go in at the trial level and you're challenging the constitutionality, always on your proof of service, include the Attorney General, always. In every issue. Remember, everybody gets a copy of everything on their proof of service. Always include the Attorney General. It's very important. Because especially when you're challenging the constitutionality of a statute. Unless the state's a party to the action, you don't have to include them because they're already notified. But say you're just going local prosecutor, municipal court, and you're going to challenge the DMV code, you have to include Dan Lundgren, Attorney General of Sacramento. He gets upset when he gets 50 stacks of paper like this every day, you know what I mean? Briefs that people are challenging. He may start looking seriously, you know what I mean, or what's going on.
So your letters to your DMV on your preliminary notice and stuff to just go to the APP?
No. That's cancellation. Here. Good one. Complete failure to instruct as to element of criminal offense violates the United States Constitution because such failure relieves prosecution of its burden of proving all the elements of the charged crime. Oops, I missed the sight on that one. Typing away like mad. complete failure to instruct as to, and the key thing is here, such failure relieves prosecution of burden of proving all the elements of the charged crime. They got to prove every element, and you got to hold the judge to it. Yeah, okay. It didn't show up here. I got 2 or 3 copies of this, so I don't know which one I'm using. Yeah. Now here's one out of San Diego. It's very important. This is very crucial to you. This is out of San Diego Federal District Court. Listen to what the court said. Vehicles owners' due process right to notice was violated when county destroyed vehicles to abate public nuisance. Even though abatement order informed owner that he was in violation of county code, and even though order cited county code section permitting removal of abandoned, wrecked, or dismantled or inoperative vehicles, vehicles were not shown to be abandoned, wrecked, dismantled, or inoperative. They've got to prove all these before they can take them. So he won against the county of San Diego. What this gentleman here, he had a junkyard out the edge of the city limits of San Diego. And he had 200 or 300 cars out there in all stages. You know what I mean? He's a collector, junk collector, like a lot of people I know, you know. Look in the mirror, Richard.
Which rusty white BMW?
And they come in, the county of San Diego. He was way out the edge of town, okay? The city of San Diego extended their city limits. He objected to it because they said, well, you got to build a fence around it. He says, no, he says, I've been here for 30 years, you know what I mean? I'm out here at the edge of town. I'm not in the city limits. He said, oh, we're moving the city limits. You're now in the city limits. Now you got to build a 15-foot fence around it. You got to clean up your yard. You got to do all this. You got to do all that. He says, I'm not doing it. So they come in and then took all his cars and destroyed them. And he let them do it. After they destroyed all the cars, when there's no more evidence, then he took them into federal district court. And the court ruled that they had to be abandoned, wrecked, dismantled, or inoperative. Every single car there, by serial number and license plate number, which they don't have because they destroyed them all. They crunched them. So how can you prove it? There's no proof. So he won his lawsuit against the county of San Diego.
So he's retired now?
Yes. That's the old court case of 1994, Ninth Circuit, San Francisco. See, the key thing, they've got to prove every single element, and these are the elements in order to impound the car. They had to dismantled, abandoned, wrecked, or inoperative. They got to prove each and every car was one of those things. You follow me?
Otherwise it would just be a parking lot.
Yes. And here's my notes. There is no 11th Amendment immunity for state citizens suing their own state. The 11th Amendment only applies to citizens of another state or citizens of and subjects of a foreign state. That's what the 11th says. A foreign state. As a U.S. citizen, you're a subject of a foreign state. So they always claim sovereign immunity. So you go in there and claim you're a state citizen, and you sue them under the state constitution. When you sue them under the state constitution, they can't claim sovereign immunity. They'll try, but you have to be able to do it. And if you want to play really nasty with them, I'm looking for a good citizen to play real nasty with the state. I've got everything done. The procedure will be to get a traffic ticket for no driver's license, no registration, no insurance. Then you remove it into federal court based on diversity of citizenship. And you prosecute it in federal district court. under diversity of citizenship. You know what I'm talking about.
Can we buy tickets for that?
And you file judicial notice, and the federal courts will make the judge, you know, our local community judges are all sleep in bed with the prosecutor. You follow me? But the federal judges don't. So if you do it right, you could have a lot of fun down in federal district court. Using the same briefs, same arguments, but you got to know them. You can't be a little bit pregnant when you do that argument.
I'll get my stepson for you, Richard.
Pardon?
I'll get my red-headed stepson for you.
Ha! He can't argue his way out of a paper bag.
Careful now, you're on tape.
That's okay. He still can't argue his way out of paper bag. Anybody will lose a stale warrant motion, you know what I mean? Everybody else can win them. You know.
Sorry, Kurt. It's the red hair gets him in trouble.
On my bulletin board, I have what they call a stale warrant motion. Okay? It's one almost every time they're being used. There's a few people who wimp out. It's ironclad brief. All you have to do is stand firm. And they'll back down every single time. But you got to stand firm. I was with one guy in Pasadena court to show you how critical it is. He filed a stale warrant motion. He had a warrant that was a year old. So he filed a stale warrant. Motion to dismiss for lack of due diligence. The judge says, I'm denying this motion. So I had prompted him already. He says, are you denying that with or without prejudice? And the judge reared back in the seat and he looked at him. He stood there and he says, I'm denying it without prejudice. When a judge says he denies something without prejudice, that means you must immediately refile it because there was a mistake someplace. Write that down. Without prejudice, refile. You can do it on every motion. The key thing is, ask, are you denying it with or without prejudice? And the judge can sit back. If he says without prejudice, that means you got to refile. You made a mistake. In this case, he says, so he went and refiled it. No, we changed a few things, you know what I mean? And the judge told me, he says, you didn't properly serve the district attorney. So next time we refile it, we properly serve the district attorney. He says, well, you still haven't done it right. I'm denying it. So we took the same identical paperwork, Xeroxed it, and refiled it again. Walked into court, he says, oh, you done it right this time. Case dismissed. He was just going to see if he was going to stand firm.
Richard, three judges recused themselves when I filed that. And the last one pretended she couldn't find the motion. And at that point, I was out of time, so I said, well, because mine were like 2 and 5 years old.
Yeah.
I said, well, geez, doesn't this state have a statute of limitations? And she about fell off her chair. And when she put it back up, she said, well, in the interest of justice, we better just dismiss it.
Yeah, they're going to try to...
They're honoring them.
Yeah, they are. They want to do their revenue, but if you stand firm. In fact, I had one attorney over in Santa Monica download this brief from my bulletin board and charged the guy $1,500 for it. And he paid it.
Sounds like an attorney.
A friend of mine. Then he came over and told me what the great attorneys were. He had an old drunk driving warrant that was 5 years old, and this attorney beat it and had it dismissed. I said, what's the attorney's name? So I was going to turn him on to the Patriots. He told me, oh, I said, I know him. I went over to the bulletin board. I said, did he file a motion to dismiss for lack of due diligence? I said, yeah, that's what he filed. I said, he downloaded from me. I said, why didn't you come to me? I'd give it to you for nothing. This way it cost you $1,500.
You'll never make that mistake again.
But I give away stuff free on the bulletin board. Other people are charging for it. No problem. Here's a good one. A challenge to subject matter jurisdiction of a court is properly brought by demur to the complaint. That's the civil side. You can do, when you get a traffic ticket, you can either fight it either civilly or criminally. It's up to you which way you want to fight it. A motion for judgment on the pleadings, a motion for summary judgment, or an answer. You know what I mean? There's different ways of to challenge the jurisdiction. You know what I mean? Judgment on the pleadings, a motion for summary judgment, a motion to strike. You know what I mean? Motion to dismiss for lack of venue. You know what I mean? You're not within their territory. You know, there's several different ways of doing it. You can't. There's no one size fits all. The challenge may not, however, be made in a special appearance by motion to quash services of summons, which lies on the ground that the court lacks personal, not subject matter jurisdiction, and jurisdiction over the moving parties. There's a court case on that, 6 Cal, 1993. A lot of patriots use special appearance and by motion to quash service of summons. You have to do a motion to squash. That's what the law said. Motion to strike, I mean. You can't use a motion to quash. Yes.
When you actually receive your citation and you sign on the line promising to appear, should you indicate that that's special appearance or?
I just put UD behind my name.
What?
UD. UD.
Okay.
Under duress. He says, what does UD stand for? I'm understudy to a doctorate. No, I can say under duress. Just put UD. Don't muddy the water. You know what I mean? The more you say, the more you're going to get in trouble. And if he says, why did you put under duress? Well, it's still the law. If I don't sign the ticket, I go to jail, isn't it? He says, yeah, that's right. So I'm under duress. I'm signing it. It's only for the court purposes. I'll be there.
But I had a case where I didn't specify that I was making a phone call to the court on a special appearance basis, and the judge denied my motion that the court didn't have jurisdiction because I granted them jurisdiction when I didn't specify special appearance in that phone conversation. So wouldn't that go all the way back to the ticket itself?
Well, I don't worry about it. It's only good for one reason only, to challenge initial jurisdiction. Once it goes beyond that, it's a general appearance.
Right. But if you want to challenge
Its special appearance is only good for one thing, to challenge initial jurisdiction. If you ask the court to do anything other than challenge original jurisdiction, it's a general appearance.
Federal rules say they abolished it anyway.
If you're going to do that, shouldn't you specify it when you get the ticket?
No. You're going to go to jail. I don't like people who go to jail. Hey, I'm doing good here. May get to that other one here. Yes.
Can you print your signature at the officer?
No, I scribble it. I could print it, but I don't want to take the challenge. You know what I mean? A motion to quash pursuant to CCP 41810 may not be used as an alternative to a demur, nor may a party to an action challenge subject matter jurisdiction of the court by a motion to quash and dismiss, and thereby avoid making a general appearance in the action. How do you do it? They just told you. A motion to strike, making a general appearance. That's how you challenge the jurisdiction of the court. Motion to strike the complaint. Here's the one important. We're going to spend a few minutes on this one. This is very important. Evidence of a relationship between a witness and a party is admissible to show bias. And once bias is established, the court loses jurisdiction. Officer, you work for the state, don't you? You're a state peace officer? Yes, I am. Thank you, officer. The officer, I want the record to reflect, the officer just admitted on the witness stand under penalty of perjury that he's biased. And once a witness admits bias, he cannot be rehabilitated. Got a court case probably right behind this one, I'm not sure. In other words, he can't be corrected. He's a biased witness.
Now, what was the question he was asking? Repeat the question to the officer.
Officer, you are a state peace officer, are you not? And the state is prosecuting you.
Objection assumes facts not in evidence.
Well, you claim you're a state peace officer, don't you?
Yes, I do.
There's no...
It doesn't mean I'm biased.
well, the evidence of a relationship, that's your... Or if a state highway patrol officer stops you, and you say, officer, you receive your pay from the state of California, don't you? Yes, I do. That's sufficient evidence right there to establish he's biased. Going through this pretty quick.
So when you establish that he's biased, you make a motion to the judge to, dismiss the witness, or?
No, just to put it in the record that he's biased and move to dismiss based on biased witness.
You make a motion or you move?
You move the court. Right there.
Don't make the motion, just move.
You just move right there because you're doing it orally. There's an error there someplace. Okay, that's what page number? 77, okay. Let's take a break for a couple minutes here, and I see a couple people wandering around. They're getting tired of sitting there. You got 1 hour to go. Try to get started here. Standing alone. Abuse of discretion is shown where lower court or other tribunal has by statute or rule or policy a discretionary power to decide an issue, and the decision makes it arbitrary, capricious, or whimsical, or an exhibition of ungoverned will, or a manifestation of unbridled power. It is the opposite of a sound judicial decision, enlightened by intelligence, or learning and controlled by sound principles of law, or firm courage combined with calmness of a cool mind, free from partiality, not swayed by sympathy, nor warped by prejudice, nor moved by any kind of influence, save one overwhelming passion for that which is just. That's the California Appellate Court in January 1994. It's whimsical. So when there's certain evidence, you know what I mean, placed before the court, and they deliberately ignore it, or when the judge is partial, that's an abuse of discretion. And you have to go up on and show the court, the appellate court, exactly how the judge abused his discretion. It's very simple to abuse your discretion. Look. Steve, why don't you get yourself one? She should have got herself one. I gotta have my coffee, otherwise I fall asleep while I'm talking. this subject is so boring, you know what I mean? That's why I get so enthused, you know what I mean? Here's a new thing in California. The right of primary jurisdiction. The California Supreme Court says primary jurisdiction, primary right theory is now applicable in California. That is where the agency has the primary right to make a decision. Under the primary right theory of pleading followed in California, a cause of action is based upon injury suffered by a plaintiff, regardless of a particular legal theory or theories upon which the plaintiff seeks redress. Where a complaint alleges a violation of different primary rights, it states different causes of action. A given set of facts may give rise to the violation of more than one primary right, thus giving the plaintiff the potential of two separate lawsuits against a single defendant. Oh. What am I doing here wrong? Yeah, I got the block on. Regardless, giving two separate lawsuits